Today on Categorical Imperatives, we are going to be talking about gun control. I am going to be giving you guys a breakdown of the draconian HR 127 that is being pushed, and we are also going to talk about why exactly it is that all federal gun control is unconstitutional. Hey, greetings and welcome back once again to Categorical Imperatives. As always, I am your host, Lockie Liberal, and I do want to thank you all so much for being here with me today. Now, if you are new to the program, I want to welcome you. This is a podcast where we're going to be using legal theory and moral philosophy to discuss current events related to law, politics, and culture. I just want to remind you guys real quick that I have opened up a couple avenues of helping to support the show if you are able to. I've got a PayPal, I've got a Venmo, and I just started a Patreon page. If you want to know how any donations you give could help the show and help me make this, help grow the channel, help make the content better, go on over to the Patreon page, and I have a post there that I've written that explains sort of my vision for what I'd like this to become going forward and how you could help. So if you've got a couple bucks to spare and you could help out any way like that, that's great. If not, that's fine too. I just appreciate you giving me your time and hearing what I have to say. So either way, I don't know, enough pouring myself out. Let's get to main topic for today. So I got a lot to cover today, and I want to start here with a breakdown of HR 127, which may be the most extreme, overreaching gun control proposal from the federal government that I have had the frightful misfortune of having to read. I am actually shocked, although not surprised, that gun control advocates still do not realize that passing laws that honest gun owners will not obey is a self-defeating strategy. Gun owners are not about to surrender their rights, and only the most foolish of politicians would risk the stability of the government by trying to use force of the state to disarm the people. Now, I want to give you guys a plain reading of this bill to make it equally helpful to lawyers and non-lawyers alike to understand exactly what it says. I'm going to be painting with broad strokes here just to get through this information in a reasonable amount of time. But if there's anyone out there who would like a more complete, like section by section breakdown, contrasting exactly what the law says currently, and then contrasting that with how this bill would amend the law, and so you can kind of see the difference between what it is and what it would be, I'd be happy to do that. Just let me know by leaving a comment down below, or you can send an email to the show. That's categoricalimperatives@gmx.com. Now, I've also put a link to the text in the description of where you can go and find a copy of the text of HR 127 for yourself. And I do encourage everyone to either look it up and I would say either follow along with me as I go through this or go and read it for yourself later. So after that, then I'm going to essentially be walking you guys through a textualist construction of the Second Amendment and how it can clearly delineate what the Second Amendment objectively protects, as well as why all federal gun control without exception is unconstitutional. But first, let's get to HR 127 and talk about what this bill would do. So it would be an update to 18 U.S.C. Chapter 44, Sections 921 through 931, and essentially what would do, first of all, is require that all firearms be registered with the Attorney General, and that including registering the make, model, and serial number of all arms, the identity and personal information of the owner, and the place where you will be storing your firearm, and essentially any person who you have in the past loaned your gun to, or any person who at the future at any point you will be loaning your a gun to for any reason whatsoever, even if it's just to go to the shooting range or go hunting or anything like that. Now, all of that above, intensely personal information that is required as part of the registry is going to be added to a database maintained by the Attorney General. And this database will be freely available and accessible to all members of the public, all federal, state, and local law enforcement agencies, all branches of the U.S. Armed Forces, and all state and local governments. And not only that, but this law would essentially act as an ex post facto law requiring current gun owners to submit all the same information, even for weapons that they already own. Now, even I would not have predicted that in the name of public safety, the government would actually go this far and make a database that would be available to criminals who might want to procure guns illegally that essentially gives them a shopping list with the exact location of every gun that someone owns, where it is being stored, and just not to mention the the way that anti-gun cancel culture already works right now. I mean, this is something that could very easily be used by people who don't like the Second Amendment to put pressure on people who have guns they don't approve of to try and get the person, maybe fired for owning certain weapons, or if you have anti-gun neighbors who want to discriminate you and try to chase you out of the neighborhood because they don't like the fact that you believe in the right of armed self-defense. Or, yeah, I mean, let's even say someone holds a grudge against you for some completely unrelated reason, and they use this database to file a false report that the owner has made a threat to hurt themselves or to hurt someone else, and they essentially get your guns seized through a false red flag law just because they know that you have them and, fuck you. I don't think that's impossible to imagine would happen. Now, furthermore, to both buy a firearm or just ammunition, even would require you to go through the full NICS background check that you already have to go through. On top of that, you would also have to complete a psychological evaluation and do 24 hours of safety training of safe use and storage. And you must demonstrate that you have firearm owner insurance. And to own what they call a military style weapon, the license you have, well, you must first get the kind of license that I just described a second ago there for other types of guns. And then on top of that, you would need an additional 24 hours of safety and live fire training. It would require an additional psychological evaluation, this time with a licensed psychologist personally approved to do an evaluation by the Attorney General. It would require a psychological evaluation of all family members or residents of your household where the gun is going to be stored to assess not only their mental state, but to have them assess your mental well being as well. You would additionally need to have any current or former spouse of an individual assess the license holder, and then you would need two additional people from outside your family or outside people who you live with who know you, essentially two additional family members or associates who would have to also meet with the psychologist and discuss your mental and emotional stability just to get the license to get a fucking what they call military style weapon, which is just a semi-automatic sporting rifle. Now, renewal of that military style weapon license would need to be done every 3 years, and it would require completing all the requirements to initially obtain the license. And in both obtaining and renewing the license every time, it would require an $800 filing fee. It would make all 50 caliber ammunition or greater illegal to possess, and it would ban all what it calls high capacity magazines. And the way that this bill defines the term military style weapon is so vague and expansive that a creative reading of this could really encompass almost every semi automatic rifle, handgun, or shotgun. And as always, in showing their perennial disregard for the rule of law, they have, of course, made the obligatory rules for thee but not for me clause in the amendment. And by that I mean that it exempts all agencies, departments, and political subdivisions, as well as individual employees of federal, state, and local government from the regulations contained heretofore. So now I want to move on to talking a bit about a textualist interpretation of the Second Amendment, as well as uh, just why all federal gun control is unconstitutional. Now, one of the most annoying phrases you will hear people use is, I support the Second Amendment, but I don't think the founders intended the Second Amendment to protect, blank, whatever. I don't think they intended it to protect, AR-15s, to protect weapons of war, just whatever they want to say. And explaining everything that is wrong with that one sentence, that I don't think the founders intended the Second Amendment to protect fill in the blank, um, just trying to explain everything wrong with that sentence is remarkably difficult. I've already done whole videos about that, in one way or another, that have been simply me trying to plumb the depths of the absurdity that anyone could say that sentence unironically. Now, I could easily name a dozen more serious issues I have with that sentence. We need to remember that the Constitution, after all, is not the law that governs us. It is the law that governs those who govern us. This is why a claim such as the Second Amendment doesn't mean you have the right to own an AR-15 is a ridiculous statement. Now, if we consider a statement that was made by William Rawl, who was George Washington's candidate for the very first Attorney General for the nation, and he described the scope of the Second Amendment's guarantee as follows. The prohibition is general, he added. No clause in the Constitution could, by any rule of construction, be conceived to give Congress a power to disarm the people. Such flagitious attempts could only be made under some general pretense by a state legislature. But if, in any blind pursuit of inordinate power, either should attempt it, this amendment may be appealed to as a restraint on both. Now, there's a few other things about this that sort of general sense of I don't think the founders intended blank that really get to me. I mean, for one, is it assumes that law is about what you think. It is not. Law is not about what you think. It's about what you know, and more specifically, what you know you can prove. Second, what the founders intended was entirely irrelevant. All that matters is what the words mean. Keep in mind, the founders were individuals. What they intended was different for each one of them, and that is a piece of information that we could never even know for sure, anyways, unless you are willing to accept a belief in government by divination. Now, what can be known is the meaning of the words in the clauses that make up the text. The Second Amendment did not grant any new protections, it reserved a pre existing right. And there is no need to speculate about what it might have meant. We can understand what it did and did not mean by going to the historical records and finding out. So today, I want to blend two discussions together that I hope will appeal to a large base of people here, from law students to legal scholars, civil libertarians, people in gun culture, and people just generally interested in the Constitution and in American history in general. Now, textualism is animated by the principle that it is the enacted law and not the unenacted intent that is binding on the public. It is a natural extension of the animating principle of a republican form of government, as was stated by John Adams in his Novangelist letter number 7, when he said that unlike a democratic form of government, a republic is a government of laws and not of men. Now, the same concept, which I think was given a even better phrasing and a more modern phrasing too, is from Bruno Leone's brilliant 1961 treatise, Freedom in the Law, where he described it as saying a free government is a government of laws and not legislation. So I want this discussion today to address some of the things we need, what some of the things we mean when we say textualism, and some of the ways in which a good textualist must go beyond the text of a particular document being considered. It will be a comprehensive interpretation of the Second Amendment and drawing conclusions from this fresh analysis about the modern scope of the Second Amendment. Now, it is a cheap perversion of the very essence of constitutional law itself for someone to decide, for example, that you want to ban an AR 15 and you just write legislation doing so without regard to the Constitution. And this perversion only grows when a supporter of that bill takes the position that they should be able to pass any law they want. And if the law is unconstitutional, then that's where the courts do decide at a later date if they choose to even grant cert on the issue and take up the case. But if you've seen my recent video on Cooper versus Aaron, you will know that it is not a responsibility of the Supreme Court alone to declare what is or is not constitutional. There is a doctrine that is known as departmentalism, which states that all government officials always have a duty to defer to the Constitution. Each department makes decisions for themselves, and if a legislator writes or even votes for a law without first confirming that they have the ability to legislate on the particular topic at hand, they are in violation of their oaths of office. You always should start with the law. If you want to pass legislation putting a federal ban on so-called assault weapons, you need to show us what clause in Article 1, Section 8 gives Congress the power to disarm the people, which they never do because no such clause exists. Now, there are two key points I'm going to keep coming back to over and over here that I want you to keep in mind throughout as we're talking about this. First, the Constitution is not the law that governs us. The Constitution is the law that governs those who govern us. The second is the recognition that first come rights and then comes government. Government is a body that exists to protect those pre-existing rights and not to take them away, and certainly not to claim a monopoly over their use. Now, I want to get to a few basic aspects of constitutional interpretation here, and two different concepts of interpretation and construction. So, interpretation is the activity of identifying the semantic meaning of a particular use of language in context. And textual construction, or any construction, I should say, is the activity of applying that meaning to a particular factual circumstance. Now, I realize that may sound a bit obtuse and overly complex, but I assure you the activity itself actually is not. It basically means we are going to establish the original meaning and apply that meaning to modern examples. So, to distinguish interpretation and construction, consider the following example. To determine whether the term arms in the Second Amendment refers to weapons or to the limbs to which our hands are attached is a matter of interpretation. To determine whether that original meaning of arms as weapons protects military-style rifles with standard capacity 30-round magazines, that is a matter of construction. So, the first Second Amendment controversy that most scholars and jurists start to quibble over is where they begin their reading. Some like to say that we should begin with the prefatory militia clause or the operative right of the people clause. And I think both of these are actually improper starting points for a two-way textual analysis. The most logical starting point is with the preamble to the Bill of Rights. Now, just like the Constitution's preamble is essentially a non-binding clause that conveys helpful information of meaning and purpose in the preceding text, the Bill of Rights preamble is much the same. So what the preamble, any preamble, does is set forth the assumed facts and purposes that the majority of the enacting legislature or the parties to a private instrument had in mind, and these can shed light on the meaning of the operative provisions that will follow. And this is the view that courts and judges have taken for many years. In his commentaries on the Constitution of the United States, Justice Joseph Story wrote that the preamble of a statute is a key to open the minds of the makers as to the mischiefs which are to be remedied, and the objects which are to be accomplished by the provisions of the statute. Now, it's worth noting that Story only referred to statutes in that passage. This principle holds true uh, for all legal instruments generally, that is, statutes, constitutions, ordinances, regulations, contracts, and so on. So the Bill of Rights preamble says that the conventions of a number of the states having at the time of their adopting the Constitution expressed a desire in order to prevent misconstruction or abuse of its powers, the further declaratory and restrictive clauses should be added, and as extending the ground of public confidence in the government will best ensure the beneficent start of its institutions. So let's establish some basic definitions to work with for a handful of terms in here that have a distinctly legal context to them, where their plain meaning might be facially ambiguous. So I am going to use Blackstone's commentaries for these definitions. This was the most popular legal treatise at the time of the Second Amendment's writing and ratification. So first we have the term misconstruction, which is an inaccurate explanation, interpretation, or report, or a misunderstanding. Next, a declaratory clause is defined as constituting a declaration of rights between parties to a dispute and is binding on both present and future rights, or an administrative interpretation or explanation of rights, status, and other legal relations under a statute, rule, or order. And finally, a restrictive clause is defined as a covenant, or it is a covenant as a promise included in a contract or agreement that somehow restricts one of the parties from taking a certain action. So, the Bill of Rights' purpose is to prevent a likely unintentional misunderstanding, which is misconstruction, or an intentional abuse of power. But what power exactly? Those powers already established in the legal document that the conventions of the several states had just assented to. Now, as the preamble says, this is to be done through further declaratory and restrictive clauses. So these declaratory and restrictive clauses only serve to elaborate on rights and restrictions already established in law. This is important because it tells us that whatever the Second Amendment protects, it is not a new or novel right that owes its existence to the amendment itself. The amendment will further clarify what is already protected and how it is to be protected. It also tells us that among the contemporaneous and antecedent auxiliary texts in the case, they mention the state conventions for ratification. Now, we shouldn't lose sight of the fact that our authoritative text is the amendment itself. This is where the major premise of its meaning comes from. So it's only after we have analyzed the whole meaning of the authoritative text that we want to look to contemporaneous texts to find facts that could help discover minor premises that will produce a certain legal liability or other harmonious consequence for purpose of construction. So, in short, we will be doubling back to the state ratification conventions after we have a reasonable interpretation of the whole text of the Second Amendment. So, the text of the Second Amendment to the Constitution states a well regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So, what does this amendment really mean? And now that we are past the Bill of Rights preamble, we need to deal with the text of the amendment and where shall we begin our interpretation of the actual text itself, and why does that matter? Now, in recent years, people offering answers to this question have often focused on the militia part of the amendment, a well regulated militia, be necessary to the security of a free state. In my view, that's the wrong place to begin. The militia phrase is what lawyers will call a prefatory clause, which is really another way of saying a preamble. It is a non binding explanation of intent. It is not the effective or operative part of the amendment. So, in other words, it is only a guide to interpretation. It is not the actual law. The actual law is the right of the people to keep and bear arms shall not be infringed. Now, notice two things about the phrase I just read. First, it refers to the right of the people to keep and bear arms. And this is comparable to the freedom of speech, the freedom of the press in the First Amendment. The founders were referring to a right already existing before the Constitution was ever adopted. In the founders' view, this is what they would have called a natural right, which in their terminology, they would have said given by God and not to be impaired by government. On the contrary, it was a right the government must guarantee. Now, another thing this phrase, the right of the people to keep and bear arms, implies is that the founders knew the scope of the right. In other words, they understood what it did and did not include, and we can understand what it did and did not include by examining the history of the founding. Now, it has always really bothered me that so many judges and constitutional writers, and just people generally, but especially judges and lawyers and such, will merely speculate about what they think the Second Amendment might mean or what it was intended to accomplish. Now, this doesn't happen on one side of the political spectrum. Liberals and conservatives are equally capable of injecting bias and ulterior motives into a text rather than going to the historical records and just finding out. Now, I will say more in a moment about what is and isn't encompassed by the Second Amendment. But this phrase refers to the right of the people to keep and bear arms. It also says that this right shall not be infringed. What does that mean? On this subject, also, there's no need to speculate because the 18th century dictionaries tell us exactly what infringe meant. In this context, the word infringe meant to reduce or impair in any way. In other words, the government shall not reduce or impair in any way the right to keep and bear arms. Now, today, political demagogues talk about imposing common sense or reasonable restrictions on the right to keep and bear arms, but the Constitution, properly understood, is clear that there is no reasonable restriction on the right, however much politicians may think they are common sense or reasonable. On the other hand, the founding era record also tells us that not every use of a weapon is part of the right that cannot be infringed. So let's look now at what it does and does not include. So history makes it clear that the Second Amendment is designed to serve four principal purposes. First is to guarantee the state's militia power of their own to balance the military power of the federal government. Second, it promotes the natural rights of personal self-defense. Third, it enables the citizenry to repel foreign invasions. And fourth, it enables citizenry to overthrow domestic tyrants and intimidate or discipline those who would otherwise be tyrants. Now, the first purpose, providing a state military balance to federal power, is more important in assessing federal gun control laws than state gun control laws. And this is because one of the most frequent anti federalist concerns was that the lack of a Bill of Rights uh, was that this had opened a way for the government to render only a select militia that would be little better than a standing army, and that without a right to keep and bear arms, the federal government is free to disarm anyone it pleases for any reason or for no reason at all. Now, here, the Federalist reply was actually one of the most consistent and persuasive arguments they made to demonstrate why this was not necessary. Because the proposed constitution, state constitutions, and common law rights uh, did this already, and a further positive enactment would essentially be redundant. The best place to turn for this is to Tench Coxe. He is possibly the first notable founder to address these concerns. Now, at the Philadelphia Convention, there was a group of people who refused to sign on to the new Constitution, and they put out their objections in a piece known as the Dissent of the Minority of the Convention. And the Pennsylvania minority castigated the majority for not allowing the proposal of amendments the proposal of amendments, and in particular amendments that would create a Bill of Rights, which would have provided in part, as they say, quote, that the people have a right to bear arms for the defense of themselves and their own state or the United States, or for the purpose of killing games, and no law shall be passed for disarming the people or any of them, unless for crimes committed or real danger of public injury from individuals. Now, Tench Coxe immediately set out to refute these objections of the Convention of the Minority. Coxe contended that the minority's fears of a federal standing army was ridiculous, as was the minority's fear that the Congress might disarm the people. And in an article entitled An American Citizen Number 4, Coxe stated, "The power of the sword, say the minority of Pennsylvania, is in the hands of Congress. My friends and countrymen, this is not so. For the power of the sword are in the hands of the yeomanry of America from 16 to 60. The militia of these free commonwealths, entitled and accustomed to their arms, when compared with any possible army, must be tremendous and irresistible. Who are the militia? Are they not ourselves? Is it feared then that we should turn our arms against each other's own bosom? Congress have no power to disarm the militia. The swords and every other terrible implement of the soldier are the birthright of an American. What clause in the state or federal constitution have given away this important right? The unlimited power of the sword is not in the hands of either the federal or state governments, but, where I trust in God, it will ever remain in the hands of the people." Now, having read American Citizen 4, Hamilton essentially concurred when he argued in Federalist number 29 that any army can never be formidable to the liberties of the people, while there is a large body of citizens, little if at all inferior to them in discipline and the use of arms, who stand ready to defend their own rights and those of their fellow citizens. Now, such was the cross fertilization of ideas that before Coxe had published his thoughts on the power of the sword in the hands of the people, James Madison had sent Coxe a copy of what would be Federalist 46, and in this, Madison rejected fears of a federal standing army with an impressive, almost mathematical certainty. He said, "Let a regular army, fully equal to the resources of the country, be formed. Let it be entirely at the devotion of the federal government. Still, the state governments would, with the people on their side, be able to repel the danger, because to a regular army would be opposed a militia amounting to nearly 500,000 of citizens with arms in hand." Madison lauded the advantage of being armed which the Americans possessed over the people of almost every other nation, notwithstanding the military establishment in the several kingdoms of Europe, which are carried as far as the public resources will bear. Still, those governments are afraid to trust their people with arms. So to Madison, this assured the federal standing army would be held in awe by popular militias ready to defend strong state governments and individual liberty, which was part of the pro-Constitution philosophy that was developed by people like Coxe and Madison and Hamilton and other Federalists. So in order to enable people to defend themselves, the right to keep and bear arms has to include weapons sufficient for that purpose. Which weapons are sufficient for the purpose of self defense will vary according to changes in technology and in society. Advocates of gun control tend to be the same sort of people who argue in favor of the idea of a living constitution. Of course, usually when people argue for a living constitution, what they really want is a dead constitution. Specifically, they want to eliminate almost every constitutional limit on the power of the federal politicians and allow those politicians to control almost everything. Yet, some of the people who think the Constitution should be manipulated to meet allegedly new conditions take a very different tack when applying the Second Amendment. To them, the Second Amendment, if it does protect an individual right at all, should be limited to militia duty with muskets and flintlocks. But if the Second Amendment is based partly on the right to personal self-defense, and it is, then this narrow view is wrong. The Second Amendment cannot be limited to muskets and flintlocks any more than the power of Congress to regulate interstate commerce can be limited to trade in sailing ships and horse-drawn wagons. Even an old-fashioned constitutional conservative like myself believes that Congress can use the commerce power to regulate railroads and air travel, although those forms of travel did not exist when the Constitution was ratified. Otherwise, the commerce power would mean nothing. For the same reason, the right to keep and bear arms must include the free use of modern technology appropriate for self-defense. Now, it is true that when the Second Amendment was ratified, a standard capacity 30-round magazine would not have been necessary for personal self-defense. But now, when criminals and terrorists have modern weapons, citizens need access to these standard capacity magazines for their own self-defense. Now, when we talk about standard capacity magazines, I want to be clear about something here. They often will talk about high capacity as being more than 10 or more than 20 or whatever. The definition of standard capacity means however many rounds the gun was meant to hold when you bought it. So if you bought a firearm and the magazine that came with it was a 30-round magazine, that is a standard capacity 30-round magazine. That is not high capacity. This is just, you can't pick arbitrary points and then just call them high capacity. It's ridiculous. Now, they also, on top of this, will need handguns and a range of other weapons. So this is one reason the Second Amendment protects their use today. Now, in addition to self-defense, the Second Amendment was adopted to enable citizens to defend against tyrants, both foreign and domestic. At this point, it becomes helpful to turn to the Second Amendment's preamble that seeks a well-regulated militia, which in 18th century language means a well-trained militia. Now, the militia that the Second Amendment says should be well trained consists of all able bodied men. Now, I use my home state of Minnesota because I believe they express this very well in our state constitution. In Article 17, Section 1 of the Minnesota Constitution, it says, quote, "The militia of the state shall consist of all able bodied male residents of the state between the ages of 18 and 45 years, except such persons as may be exempted by the laws of the United States or of the state." And that was pretty much the American founders' view of this matter. If you read Madison's language in Federalist 46, you will see what I mean. It is pretty much the understanding that our fathers and our grandfathers would have had when they understood that gun use was something that can be taught. And actually, in fact, safe gun handling and usage used to be something that was very commonly taught in schools. It wasn't that long ago that a lot of public schools had shooting teams and rifle clubs and things like that. So Yeah, I'm sure there's a few people out there listening to this right now who can remember there being a shooting range at their school. Anyways, essentially, according to the Second Amendment, what is wanted are all men of military age, well trained in the use of weapons. And why is this? Well, because as the preamble tells us, this is necessary to the security of a free state. And by a free state, the Constitution means a free country. So all men of military age should be well trained in weaponry so that America may survive as a free country. Well, what weapons? Obviously, the muskets and single shot rifles that were used during the Second Amendment's time of adoption are no longer sufficient to do the job. Today, the Second Amendment protects a range of weapons appropriate for citizen militias resisting foreign invaders and tyrannical politicians. There are still plenty of people who do think that this technological turnaround exists, but this argument really borders on the frivolous. Nobody thinks that the free press clause protected only materials that were printed on a late 1700 movable typeface printing press. And few people would say that the constitutional authorization for the Army excludes the Air Force because that didn't exist in 1787. Indeed, people around this time of the framing recognized that there would be technological change. For instance, they understood the printing press was once new technology, and there is actually an excellent passage on this from a great jurist of that age named Francis Holt in his 1812 legal treatise known as the Law of Libel. And he says, the rights of nature, that is to say, the free exercise of our faculties, must not be invidiously narrowed to any single form or shape. They extend to every shape and to every instrument in which and by whose assistance those faculties can be exercised. I have a right to walk. I have the same right to run. And if by the exertion of ingenuity I could invent a way to fly, I would have the same natural right to fly. The same character, therefore, of natural rights is conveyed to every right which is natural in its origin and principle through all possible modes and instruments of exercising and launching it into action and employment. Now, of course, the same is true of arms technology as much as any other technology, such as press technology. Now, speaking of frivolous arguments, uh, this is where gun control advocates will often interject with an argument that is something like, well, does this mean that citizens have the right to hoard naval artillery and atomic bombs? To which the answer is no, obviously. The Second Amendment doesn't encompass naval artillery or atomic bombs any more than the First Amendment includes falsely shouting fire in a crowded theater. Just because gun control is unconstitutional doesn't mean there aren't limits on the right. These don't have to be the same thing. The language and purpose of the Second Amendment, as well as its history, tells us what it excludes and what it includes. Naval artillery and atomic bombs are not customary for personal self defense, and they never have been militia weapons used for repelling either foreign invaders or domestic tyrants. In fact, the Second Amendment itself refers to the right to bear arms. That would suggest the right to carry arms, referring to arms that are capable of being carried by one person. Now, let's focus for a minute on another purpose of the Second Amendment, and that is protecting against domestic tyrants. We tend not to discuss this purpose much, but it might possibly have some relative to the authoritarian types who currently dominate the federal legislature, as well as the legislatures of the several states. Politicians in America right now tend to fall into one of either two groups. There are those who generally favor freedom, but also strongly support law enforcement. And there are those who are skeptical towards law enforcement, but nevertheless seek to expand the power of government in many areas of life, and particularly in economic affairs. Now, it's not intuitively obvious which of these two groups should be in favor of gun control. You might think that those who favor economic freedom might be for gun control as a way of backing law enforcement. Or you might think those who favor more economic regulation might be against gun control because they are skeptical about law enforcement and might not want to give police a monopoly over weapons. Now, the fact is that both of these groups will tend to favor some form of gun control, and we need to be honest about this. It is very easy to call out one side who is far more controlling and overbearing, and you know exactly who you are. But even the conservative view uh, often will put patently unconstitutional restrictions on firearms, and I want to briefly explore both groups' motivations. But the thing is, we all know the situation in real life. In real life, the biggest advocates of gun control are precisely those who want to lord it over the rest of us in nearly every other aspect of life. Why is this? Well, let's reflect on the fact that the modern era of gun control began with the Federal Gun Control Act of 1968. This law, if a patently unconstitutional act can even rightly be called a law, was passed in the wake of a few ghastly political assassinations. Now, I don't think it's a coincidence, uh, and that it is reasonable to assume that those who wish to fasten more and more fetters on the productive people of American society might consider that one day they might go too far and face physical and armed opposition. Indeed, just the fact that many citizens are armed has a moderating influence on authoritarian politicians. Now, to close out here, the author of the first draft of the Second Amendment was James Madison. Now, Madison's favorite book of political theory was Aristotle's Politics. Several times in that work, Aristotle makes the point that all citizens should have weapons and that only those with weapons should be citizens. Otherwise, he wrote, those that are disarmed are the slaves of those who are armed. This point was made by, in another way, by Jean-Louis Delhomme, a Swiss jurist. Delhomme wrote a book on the English Constitution that we know Madison read, and that was a source for many of the other American founders as well. And in speaking of the need for an armed citizenry, Delhomme wrote, quote, "The power of the people is not when they strike, but when they keep in awe. It is when they can overthrow everything that they never need to move." And Manlius, who was a Roman consul, included in all four words when he said that the people of Rome ostendait bellum pacem habitatis, which means if you look towards war, you shall have peace. So the widespread ownership of firearms, therefore, helps to preserve freedom and usually without the need for armed violence. When politicians limit or harass gun ownership, the threat is far wider than the threat to guns alone. By reducing the number of citizens who are armed, gun control emboldens authoritarian politicians to control everything else we do and thereby imperil freedom generally. Well, that is going to do it for me today. I want to thank you so much for spending some time with me here today on Categorical Imperatives. If you like the show, feel free to give it a thumbs up. Leave me a comment. Let me know what you thought. I really love getting people's thoughts on these shows, and let me know. And then, yeah, if you are able to support the show, also additionally on top of that, by heading over and maybe contributing a little bit over on Patreon or PayPal or something like that, that would be greatly appreciated. But in the meantime, I just want to say thank you for spending some of your time here with me today. And if nothing else, if you can't do anything else, I ask you just take a moment and think of someone you know who you think would like this show, and just share the episode with them. And if you would do that much to help me grow the channel, I would be truly, truly grateful. So until next time, this has been Lockean Liberal for Categorical Imperatives. And as always, Delenda est Carthago.